Hello everyone, you're welcome to this edition of The Inside on Equinox Television, live from our headquarters in Cameroon's economic capital, Douala. I am Pablo Jonathan. In this edition of the program, we are going to be examining what the law in Cameroon says about public manifestations, and we will take a look at this in relation to efforts to preserve public peace and stability in the country. We'll be looking at what the law says and what is happening in the country as far as public manifestations are concerned. Meet our guest in some few seconds. Thanks for staying with us in this edition of The Insight. For several years, the manifestations, public manifestations organized by opposition, political parties and civil society organizations in the Republic of Cameroon has often met with stiff resistance and repression coming from forces of law and order, and even security and defense forces, and of course the administrative authorities. And today we're going to be looking at what the law says about public manifestations. Recently, some administrative authorities in the Republic of Cameroon have taken some decisions and have issued releases banning unauthorized, in some cases undeclared, public manifestations in the country. And most often when these decisions are taken, the administrative authorities highlight the efforts to preserve peace and stability within the Cameroonian society. And today we are receiving a legal mind, a member of the Cameroon and Nigerian Bar Associations, Barrister Tanfu Richard. You're welcome to the program.
Thank you, Mr. Babila. It's always a pleasure to be here to be able to enlighten Cameroonians. The pleasure is all mine.
Right, and we want to enlighten Cameroonians today and all other persons listening or watching us across the world on legal issues, the legal framework governing public manifestations in the Republic of Cameroon. Let us begin by indicating that the atmosphere, the socio-political atmosphere in the Republic of Cameroon has been tense for several months, for some years today, as a result of some public manifestations that are often met with stiff resistance and repression coming from security and defense forces. Of course, behind the security and defense forces, we have the administrative authorities who say that they want to preserve public peace and stability. Now, what does the law say about public manifestations in Cameroon, Barrister?
Yes, to be able to understand the subject itself, you first of all have to be able to understand the hierarchy of norms in Cameroon. In Cameroon, you have the constitution, you have national laws, and you also have international instruments. Now, when you look at how laws are classified in Cameroon, you understand that when reading the constitutions, particularly in its sections 45, which states that duly ratified treaties and international conventions are the override national laws, meaning that international laws or international instruments ratified by Cameroon are superior to the constitution.
In other words, when there is
if there is a conflict between a national law and an international law, the international law overrides the national law. Right. Now, when you come down to the national law, we have the laws that were passed in 1990, precisely law number 90/05 of 19 December 1990, that talks about public meetings and demonstrations. Now, what that law says is that you are free to air or to organize public meetings or processions. Now, but you are subject to what they call a declaration, And if you permit me, I would like to read the sections of the law so as to be able to give to cite the law in its integrity.
Go ahead, Barrister.
Yes.
And to get into the law to
Exactly.
be able to understand all the issues surrounding public manifestations, public protesting.
The law I just cited, law number 90/55 of 19 December, to lay down public meetings and processions, states, when you look at Article 6, Article 3, first of all, it says that any meeting held in a public, Article 3 states that persons shall be free to hold public meetings no matter their purpose. So you are free to organize, to hold a public meeting no matter the purpose. However, such meeting shall be subject to a prior declaration. So when you fulfill that, if you want to hold a public meeting and you fulfill those conditions, you have not violated the law. When it goes further to talk about public processions, all processions, demonstrations, parade, marches, rallies of persons, and in general all processions on the public highway shall be subject to prior declaration. So if people want to go to the street to manifest on a public highway, they are bound with these articles of the law that they have to declare. It is not like they are going to the administration to obtain an authorization. No.
What is the content of that declaration? What is
in the content? You give the purpose, because when you look at which section is that? The purpose of the declarations, the content, I think the law does not tell you what exactly the content should be. You are the one who defines your content. And the law does not categorize instances or subjects which you have to go in for a declaration. For example, I want to take what is common. For example, people can decide that we want to chase away the President of the Republic. That is a purpose. That is what motivates them. The law does not restrict that you should not deposit a declaration because you want to chase the President of the Republic. No. So the purpose is an inalienable and sacred right. It's a freedom that you have to express an opinion.
So the law does not prohibit
exactly the law
any public meeting or procession
exactly
because of the object or the subject,
exactly
the purpose of that manifestation.
The subject or the content of the manifestation is not prohibited by the law. It can be anything, provided that it is not against the law. Now, what you have to do is that the declaration that is being referred is addressed to the subdivisional officer or the divisional officer of the subdivision. Once you do that,
where the meeting has to take place.
Exactly. The jurisdiction where the meeting has to take place, you addressed your declaration, or you table a declaration to that divisional officer, and upon receipt of your declaration letter, he has to issue you a receipt acknowledging that you have declared your manifestation, be it a public meeting, be it a public
procession.
Exactly. So now, when you do that, when you go further to read section 8, the administrator has two things to do. Either he issues you a receipt acknowledging the deposit of your declaration, or if he thinks that there will be any disturbance to the peace, he can either reschedule the avenue. You see that even the law itself.
All right, we'll come to that in a short while. I want to be shown that we are progressing and getting everything in place. Now, the declaration. When you come to declare, what are the things that you are declaring? The place, the venue of the meeting,
the time,
the subject, the people who concerned.
Exactly, and the signatories. People, at least 3 persons have to sign the declaration. So you should understand that this law are a subset of laws contained in the Constitution, because when you read at the Constitution itself, like the preamble of the Constitution, you see a series of rights or liberties that gives Cameroonians the possibility to exercise their rights. For example, freedom of expression, freedom of opinion. All these are stated in the preamble of the Constitution. And our Constitution goes as far as affirming its authority. It affirms that it's going to respect rights which are as well contained in the Universal Declarations of Human Rights, in the African Charter, and in other international instruments. So when you have those series of rights being guaranteed by the Constitution, you now have a national law that still accompanies you into the process. There is no issue or no fear to make when you want to express your opinion, be it public, because if it is a public meeting, the law tells you what to do. If it is a demonstration or a procession, the law tells you what to do. I think the law is clear. It does not restrict. It tells you what to do and what not to do and how to do it.
Now, after you have told the divisional officer the date, the venue,
yes,
from which spot
to which spot,
this part of the town to this other, passing through this area, everything described, and of course the time and the people who are involved, the signatories and everything, what is expected of the administrator beyond just issuing a receipt to indicate that we have received this declaration from this political party, from this civil society organization? Beyond that, what is he expected to do? You were reading section 8.
The administrator acknowledges the deposit of your declaration, and the administration can only be called if there is an issue, because those who have deposited the declaration, you have 3 people who have taken an obligation to ensure security of the manifesto. Have to move, maybe take this stretch of the road and not this.
And here,
exactly,
don't go beyond this limit.
Good, exactly. And when the administrator thinks that peace is being threatened, that is when he can suspend, he can cancel your declaration. And when he cancels it, he has to notify you, not just because he is the one to interpret or judge the serenity of. He is the guarantor of the peace. He appreciates the peaceful atmosphere that may reign. When for example, he takes the decision of maybe giving a ban order, he has to notify you of that decision, so as to enable you as well to file in a counter complaint before the High Court, so that the judge can now reconcile both parties and see who violates the law or who doesn't violate the law. So the administrator cannot even just start giving the ban without you making a declaration to him. You understand? Because what we observed of the current situation was that we saw notes of governors issuing bans. One, the notes are being issued by the governor, who is not the competent authority. The competent authority to take such orders is the divisional officer, who is the head in a subdivision. Now, when the governor takes that decision, he is violating the law. That is not what the law says. It is not within his prerogatives. And a divisional officer cannot, on his own volition, issue a ban when somebody has not made a declaration. I hope you try to understand the two contexts. So it is only when a declaration has been tabled to him, which he has 2 things to do. Either he issues a receipt he issues a receipt immediately of when you deposit the declaration, he automatically issues a receipt. In the event where he doesn't issue the receipt and thinks that there is a disorder, he redirects the venue, or if he gives a ban, he has to notify the people who came and deposit the declaration.
But the governor is above the DOs, the SDOs. He is above them.
No,
why is it illegal?
No, that is not the spirit of the law. The law says that. The law says the district head or subdivisional officer receiving the declaration shall immediately issue a receipt thereafter. That is section 8. The law prescribes which authority is competent to do what. Had it been, it just said an administrative authority, yes, but here it has precised the district head or the subdivisional officer. So you already know who is a competent authority. So it can't be the governor at this stage. However, if he deems that the planned procession is likely to seriously disturb the peace, he may, as the case may be, schedule another venue or route for it. Prohibit it by order, which he shall immediately notify to the signatory of the declaration at the elected domicile. So the law is not left to interpretation to know whether it's, if it was the governor, the law will have clearly stated that the governor should do this. If it was the senior divisional officer, the law will say senior divisional officer. But the law here is precise. It says the subdivisional officer, which is clear. So I don't expect to receive a note from the governor or the senior divisional officer. No.
So from the point of view of the law, the decisions taken by the governors are illegal.
Yes, you can even argue it as far as this. You know, decisions by the governor do not supersede laws in the constitution, and laws in the constitutions are not superior to international instruments. I take a practical example. The constitution may say that, an international instrument may say that you are free to express your opinion. If the constitution says that you are not free or restricts that, automatically, as it stands today, the international instrument will override our constitution.
Ratified by Cameroon.
Exactly. If you look at section 45, it clearly states that duly ratified international instruments override laws that violate those instruments. So it is not something we have to argue. The constitution, when you look, for example, when the constitution in the preamble says that we, the people of Cameroon, affirm our attachment to the fundamental freedoms enshrined in the Universal Declaration of Human Rights, the Charter of the United Nations, and the African Charter on Human and People Rights, and all duly ratified international conventions relating thereto. When you even go further to section 65 of the Constitution, section 65 tells you that all what is stated in the preamble of the Constitution is part of the Constitution. So somebody will not tell you that no, the preamble is not part of the Constitution. Section 65 says the preamble shall be part and parcel of this Constitution. So just to confirm what I'm saying is that if an international instrument says that this is the position of the right to be respected, a national law cannot violate it, because Article 45 of the Constitution says duly approved or ratified treaties and international agreements shall, following their publication, override national law, provided the other party implements the said treaty or agreement. So Cameroon was free to go and ratify international treaties because Cameroon is not an isolated state, which is normal. So when you go and ratify international instruments, an international instrument gives right to citizens, be it political and civil rights, you are bound to respect it. No. So a national law cannot come to violate such rights.
The law, according to the law, from what you just explained now, the decision to either prohibit or reorientate or direct any public meeting or procession is not in the by the governor of the littoral region, for example. He says all undeclared public manifestations, undeclared public manifestations. The law says that all public meetings or processions should be declared, and he says meetings that are not declared should not take place.
Yes, what you should also understand is that the law talks about public meetings, and this same law that guarantees public meetings as well cannot violate it. They cannot restrict you from organizing public meetings. So the governor cannot ban somebody from organizing public meetings. When you want to organize a public meeting, you declare it. So if the governor is coming in to maybe ban meetings that have not been declared, on the one part, he may be correct. But he cannot restrict people from gathering. We are free to gather. But if we have to gather ourselves for any public meeting, it should be declared. So, and when you go as far as violating individual rights, like right to association, that's an individual right. I am free to associate. I am free to take part in a meeting. And when you decide to ban it, you are infringing on my personal rights. So, when he says that it is as if you have to hold a meeting, for example, a meeting in a private place, it will pose a problem. I think it is when the meeting is maybe held in a public space that it is being considered as a public meeting. You will not infringe on personal rights and think that, to me, the decision of the governor, to me, violates inalienable and sacred rights of citizens, because not only the act has not yet been posed, but is already restricting the liberties.
So, but often politicians, notably those of the opposition, say that the government is not proactive. The government is only coming to take action when something has happened, when something has been done, when the damage is already there. Government is now coming to try to fix things. And now government is looking into the future and saying, okay, this should not happen, because they foresee, the administrative authorities, they foresee that if this happens, if people take to the streets without proud declaration as prescribed by the law, that may jeopardize public peace and stability. So they're taking this action as a kind of preventive measure.
Yes,
don't you think so?
But just that it is going in contradictions with the law, because when the law says that persons shall be free to hold public meetings, no matter the purpose, that is section 3 of the law that talks about that. You are free to hold public meetings, no matter the purpose. Any such meeting shall be subject to declaration. So, we are free to hold public meetings, no matter the purpose, but we are subjected to declare. So when you, the governor, now you come and say we should not hold public meetings, you're already infringing on our rights. You're already infringing. So we are free to organize, to hold public meetings, provided we make a declaration. So he should wait and see that the public meeting that is being organized has not been declared. Then that's where he can now come into action.
Now, when a meeting is organized, declared, what is expected of the administration, the security and defense forces?
Yes, what is expected of them is to accompany the manifestants, because, like I said, they are not even invited, because those who go and do the declaration already stand as guarantors of the security and the peace in that event. So it is only when only it has escalated, that those people can now make recourse to the forces of law and order. And when they come to the field, is to guard the manifestants, not to use arms or fire or fire against them. No. You see, there is even a law on maintenance of order, still a 1990 law, that tells you how law enforcement officers have to operate whenever they want to carry security measures. They are restricted from shooting. They can only use tear gas if and only if they have been assaulted, or that people have used violence to them. They can only make recourse to arms if they have an authorization. So when you see maybe a public meeting going on and you have the impression that law enforcement officers have shoot the manifestants, you keep to wonder if we are really in a state of law, because the law forbids them from doing that. They are not there for that. They have to, if they discover that the security of the state is being disturbed, they take preventive measures to make sure that the situation does not escalate, not to shoot at the manifestants. No, it is strictly forbidden, except they have an authorization.
No, the law, which you just read, said nothing about whether if people take to the streets to protest against this or that, it can be banned because they want to protest against the head of state. It can be banned because they want to protest against the governor or the administration and so on. But if somebody takes to the street today and begin to say, for example, the head of state should step down, he will be charged with incitement to violence, insurrection. These are some of the terms that will start coming up when he
there is a term you call, there's what they call national sovereignty. National sovereignty belongs to the people. The people are the one who give the mandate to them, who voted them, and it is being exercised by either the President of the Republic or the National Assembly. So national sovereignty rests on the people. So if the people today decide that we want to tell the president to go, it is their right. You can't tag them as with offenses of insurrections or whatsoever. They have not armed themselves to do that. They go to the street.
Some are referred to as terrorists today, simply because they took to the streets in Bamenda, asking that the road should be...
How do you become a terrorist when, for example, you're on the street with a peace plant, having just your voice to speak, your mouth to speak? It is incomprehensible. You have not been armed, maybe with guns, to chase away or to bring down an institution. I think if we go by understanding what freedom of expression means, freedom of opinion means, those are the foundations. If we are not able to understand what those terms mean to us, then anytime that somebody will raise his voice to demand something, and what is curious is that when the people who are voted into office, when they want to accede to those power, they come and meet the people. It is the people who vote them to power. Now, if I vote you to power and I discover that you have taken the power, or you are now in power and you are not yielding to what, for the reasons why I voted you, I still have the right to claim it back from you. And that is what Cameroonians have understood, and they are thinking that they have given their vote to somebody who to them maybe is not active. We have had instances where we expected the head of state to maybe appear and speak to his citizens, like what happened in the Northwest and Southwest. Had it been the head of state came out to speak, maybe the situation won't have been this. But when you want to use force, repression, you may escalate, you violate people's rights, and that is how it turned out to be something else. To me, I think we should remain at what the provisions of the law says. The law does not say that if you have to manifest, they should shoot at you. No. The law gives you what are the mechanisms when you want to organize maybe a march or a public procession, what you should do, what the administrator is expected to do, and if that is being done, where would the violence come from?
All right, Barrister, let's take a look at what the newspapers reported this week, the press review. We begin with the Voice newspaper, and the Voice newspaper this week reported that Operation Clean Bamenda, northwest region of the country, is subjecting the city to what is qualified as a near curfew. In the meantime, the paper indicates that the United States of America Congress passed a firm resolution on the Anglophone crisis, compelling the government of the Republic of Cameroon to provide concrete answers to the socio-political and security tensions in the northwest and southwest regions of the Republic of Kamer. And the Sun newspaper also talked about Operation Clean Bamenda. This is an operation being carried out by the security and defense forces with the aim of putting an end to separatist activities. And the Sun newspaper says that Bamenda is paralyzed as military battles armed groups. And the Herald Tribune newspaper says that Bamenda City Mayor, who took a decision recently in collaboration with the senior divisional officer of the Nizam division, banning the circulation of commercial motorbikes and even private motorbikes in some parts of the Bamenda 1, 2, and 3 subdivision, has said that the decision is a bitter pill, but is intended to put an end to the crisis. The Horizon newspaper indicates that the Anglophone struggle implodes. It talks about the Anglophone struggle, which has been pulling on for close to 4 years today, leaving the people in a very difficult situation as far as the socio-political and security climate in those two regions is concerned. And also the Post newspaper talks about one of the giant companies badly affected by the Anglophone crisis, the Cameroon Development Corporation, and the paper asks a question: shall the CDC be buried in same grave as marketing board? Looking at the impact of the Anglophone crisis on the Cameroon Development Corporation. Recently, some workers of the CDC went on strike over several months of unpaid salaries. The median newspaper says that Yaoundé and Douala, the two major cities in the Republic of Cameroon, have been put on red alert ahead of the planned protest move of the political parties of the opposition, CRM and others, coming up on the 22nd of September 2020. And of course, the Horizon newspaper also indicates that the governors of the Central and Littoral regions have banned unauthorized rallies, and the Guardian Post reports that government struggles to kill the 22nd September protests. And municipal updates highlights fireworks nationwide ahead of regional elections, with some happenings within the CPDM, the ruling Cameroon People's Democratic Movement, and of course elections Cameroon ahead of the municipal, or rather regional elections before December 6, 2020. And Eden newspaper in the same light highlights rumbles of regional council elections, indicating that the president of the republic, who is the national chairman of the CPDM political party, slams party barons and parties, other parties in the race, and of course other parties in the race who are equally carrying on with the plans for the regional elections. It should be indicated that there are several opposition political parties that will not be taking part in the regional elections, including the Social Democratic Front, the CRM political party, the CPP, the PAP, and others. That's it for the press review. With us, we are still with our guest, Barrister Tamfo Richard, who is a member of the Nigerian and Cameroon Bar Associations. Barrister, if somebody takes to the streets today, will he not be charged with hostility against the fatherland, attack on the personality of the head of state? We often hear these terms: outrage au chef de l'État, tentative de déstabilisation de la nation. Will he not be charged with these crimes of attempting to destabilize the country, attacking the personality of the head of state, hostility against the fatherland?
No, even the law goes further to tell you that should you violate those provisions, what you are entitled to. When you look at sections 9, it talks about which provisions of the penal code you will be violating should, in case you don't conform yourself to this, without prejudice, if need be, to the institution of proceedings for felonies and misdemeanors. The penalties provided in section 231 of the penal code shall apply to any person who take part in the organization of a public meeting which has not been subject to a prior declaration. So the court this law does not give the possibility or to the prosecutor to charge you for whatever. It tells you that if you violate this law that regulates public meetings and processions, you will be punished under sections 231 of the penal code. And the punishment that you may be charged, you may be sentenced with, will go from 15 days to 6 months imprisonment, or with a fine of from 5,000 to 100,000 francs. So the code does not give the possibility to the prosecutor that once, for example, you are being caught in a public meeting or a procession, for them to start charging you for secessionist, this. No, the law guides the state prosecutor that you have to charge such a person who violates the provisions of this law under sections 231. It is very clear. And it's, you see, what disturbs the mind is that we have laws but we do not apply them. You have a law that tells you that if you only be charged if you take part in a public meeting that has not been declared. So once I do the declaration, I'm not expecting an authorization from the division, from the divisional officer.
But if you do the declaration,
I do the declaration,
and the administrator says no, there is a threat to public peace with regards to the context and everything that is happening within the country or within the area where you want to organize your public meeting or procession, and you go ahead to do what has been qualified as challenging the public authority to go ahead and organize it, is it not illegal?
When you do the declaration and the administrator thinks that the divisional officer thinks that he can ban it, he has to notify me. What always happens is that once you make the declaration, the administrator bans it without notifying you. He doesn't give you the possibility to drag him to court, to the high court, to contest his decision. So if on his own part I do the declaration and he bans it without notifying me, meaning that he has not fulfilled his own obligation. If he's banning it, he must notify me, so that I now have the possibility to contest his decision before the high court. And only when that is being done the right way, then now that if I proceed, I can now fall under that section for violating the law. But if the declaration is done and the administrator bans it without notifying me, I don't see what if I continue with my action, I'll be held by that law.
So if a public meeting or procession is declared,
yes,
and the administrator bans without notification, which is a violation of the law,
exactly
to what you're saying now, and then you go ahead because the administrator violated the law to challenge the public authority to organize it, will you also be violating the law? Or?
Good. Two wrongs cannot make a right. He violates the law, I proceed with my action. How will he now charge? He cannot charge me because he himself did not respect the law. So it is left for him. I started by making my declaration, which he thinks is a threat, bans it. He has to notify me, because when you do the, it's not like he has to start searching for you. You have given your address and everything. Now if he sits after giving his ban, he sits without notifying you, how will you be able to contest the decision? In the cousin possible.
Coming up, interviews of the week.
On the last day of adjournment, that was the 20th of August, the president of that panel, Justice Mejinda Menjima, informed the court that he was going to take an adjournment because his panel had been, all of them on that panel had been transferred. And because of that, he was not in a proper position to start any matter afresh. And he adjourned the matter to today. Hopefully, we were thinking that by today, that panel would have moved. When we came to court today, we were surprised to find out that it was the same panel that we met last time that was listed on the court list. And when the court came in, the president of that court, Justice Mejinda Menjima, informed the court, as he did last time, that he was going to adjourn all the matters because because they had been transferred. Same reason he gave last time, they had been transferred. And they were not going to start in case because in a week's time, they will be taking up their various offices in their respective places that they have been transferred to. Curiously enough, they started by calling number 1, number 2, number 3, number 4. They skipped number 5. They didn't call number 5 because our appellant's matter was listed as number 5 on the cost list. And went on and called all the other matters. When they were done with the other matters, we, counsel for all the appellants, informed the court that our matter had not been called up. He instructed the court, the registrar of that court, to call up the names of our clients, the appellants, Sisiko and 9 others.
They took all these records of appeal, served our clients at the Konengi principal prison, and they denied us access to go to the prison and collect these record of proceedings in order to file additional grounds of appeal as we had indicated in our memorandum of grounds of appeal we filed. And yet they expect us to prosecute the appeal on behalf of our clients. These are appellants who cannot see their lawyers, who cannot discuss with their lawyers, but their lawyers have to defend them at the level of the court of appeal.
It is clear that this panel came in with their homework cut out for them. First, we cannot reconcile the fact that they came in a few minutes they said they were going to adjourn all the cases on the course list because they had been transferred. That means a recusal. They had recused themselves. And then they just turned around in less than 10 minutes. After they had adjourned about 15 cases, they just turned around and called our clients, suspended the session, came back and gave a judgment. The second thing is that it is unheard of anywhere in the jurisprudence of the world that represented people, appellants who were in court with their counsel present, could not be heard. The former bâtonnier stood up to intervene, he was hushed down. The lead counsel, Barrister Young, stood up to intervene, he was hushed. 2 other counsels stood up to intervene, and they were cut off. So this was a master plan. They had their work cut out for them, and they needed to do this today, and they did it.
The divisional officers, the mayors, the delegates in charge of education, and other stakeholders are on the field to educate, to inform, to sensitize, and mobilize all these rights. Let us act now by encouraging all our children of school-going age to enroll in schools and effectively start classes on 5th October 2020.
Here is drainage. We have a lot of problem here. We have been suffering for long. While waiting for them, we try to do our self-initiative according to the job that we have been seeing here. Because the drainage, the cover was broken here. So we try to contribute money to try to save, to try to have at least a good water drainage while waiting for the council to come to help us. You cannot do anything in your door during rainy season because of overflowing.
Those were interviews of the week. But it's the time for Richard. Let's now go international to take a look at what international law, international legal instruments say about public meetings, processions, expression, manifestations, or whatever.
Yeah, the basic text when we talk about international instrument is the Universal Declaration of Human Rights that was adopted by the United Nations General Assembly on the 10th of December 1948. That is the basic text as far as human rights are concerned. And when you look deeply into that law, into that declaration, especially Article 19, which you permit me to read, it says, everyone has the right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. So this is a section of the Universal Declarations that gives you freedom to express yourself, to express your opinion, to speak what you think. So having that, and you have others, because you have in the Covenant on Civil and Political Rights, you have the African Charter on human and people's rights. So when you peruse all those international instruments, you will find that citizens have political rights guaranteed by those instruments, and even civil rights, which should not be, for any reason, be violated by states who are parties and signatories to those.
And Cameroon is one of the signatories.
Yes, Cameroon is one, and Cameroon even makes it more clearer when you refer to the provisions of the constitutions, which, like I have cited 45, it tells you that those laws override national laws, meaning that all the rights and freedoms that are being guaranteed by international instruments automatically apply in Cameroon and are even superior to what exists in Cameroon.
All right, coming up, we're going to take an extract of statement by the general manager of Kamer Plantations. This is one of the giant companies, state companies, suffering the effects of the Anglophone crisis. The company is facing enormous difficulties due to challenges, multifaceted challenges, and the general manager of the company spoke to me in one of the editions of the Insight. Take a listen.
The major challenges are paying wages for the workers who are currently working, the few who are currently working, who are keeping the company afloat now, like those who are working in the Indian mill and the plantations. We are unable to pay their wages. We are able to pay the bills for the smallholders because we rely on the smallholders for their crop to be able to supply all their crop to produce oil, and without them it is very difficult because our target has always been that we should have more crop from small holdings than industrial plantations. The other factor is that we want to start the lobby part of the mill. The lobby part of the mill cannot start when we don't have capital, start-up capital, because after the damage which was done in April 2019, when we wanted to start, the damage was huge. The factory was vandalized. Our installations were damaged. So we need to inject a lot of money there to be able to. And we were counting so much on our resources, which are held in the Ministry of Plan, because we, on instructions of the Prime Ministry, we carried out some operations on the phase 2 of the development projects in the Bakassi area, the Bakassi development, oil palm development program, where it was intended to occupy this area, use this plantation to occupy the area and populate the place with more Cameroonians than before. Unfortunately, this job was done, was received, there was joint commission which came and received the work which was done, and all the necessary documentations were done for this money to be reimbursed as it was stated, as promised by the Prime Minister at the time. But we are in 2020. Since 2016, this project, this money has not, or the program, I don't know how to call it, has not moved from the Ministry of Plan to Ministry of Finance to be able to pay this money. And that's what we've been struggling for reasons we cannot understand. We've done everything possible. The presidency has written for this money to be paid. The Prime Minister has written for the money to be paid. But
the file is blocked at the Ministry of Economic Planning and Regional Development.
It's still blocked there. We cannot understand why. We don't know, but just so it is above and imagine if this instruction comes from quarters, who gave us instructions to work, and they say okay, pay. They say produce all the documents. We provided the documentation, and the fact cannot move from where it is. Then there's a problem. Then there's something wrong.
We're talking about how much, Mr. GM?
2 billion francs, to which we are indebted to NFC and Afriland Bank, who money we used to sponsor this project.
The project, His Majesty Mekanya Okon Charles, General Manager of Pamo Plantation, speaking there about the challenges that the company is facing. And we are rounding up this edition of The Inside. Barrister, the management of public protests in Cameroon, what should be done by who?
Yes, the law is clear. What the people agitating or programming manifestations should do is that they should declare their manifestations. Once they have declared it, the administrator takes cognizance of it, and the administrator should accompany those manifestants for them to express their opinions in a free environment. The administration should not be repressive. The administration should not use the public forces or allow the public forces to use their arms. No. If the manifestations are peaceful, what is expected of the forces of law and order is to guide them to the process until the manifestants are through with their procession. Now, when that is done, will come out, all the parties will be happy. The manifestants will be happy that they have expressed a constitutional right provided by the law, that is freedom of expression or opinion. The security and law enforcement officers will also be happy that they were Republican in guiding the manifestants and no incident has happened. So we do not expect that manifestants should maybe break stores or whatsoever. No. We don't expect seeing police officers shooting or using their arms to shoot manifestants. That will be going against the law.
There should be no violence
exactly
coming from
both sides.
Barrister Tamfu Richard, member of the Cameroon and Nigerian Bar Associations, thank you for joining us today.
Thank you, Mr. Babila. The pleasure is all mine.
Thanks, ladies and gentlemen, for staying with us. Goodbye.
Désolée, je suis arrivée tôt.
Je voulais te voir entrer avec tout ton éclat.